to the 50th episode of Democracy at the Crossroads, a platform where we speak truth to power. The only objective of this platform is to speak up to save our precious democracy and its lodestar, the Constitution of India, from the predators of all kinds. Last we discussed the case of one predator, Abhijit Gandopadhyay, who sucked up to India's ruling party, the BJP, while he was a Calcutta High Court judge. He has now resigned and embraced the same party to contest the Lok Sabha election on its ticket. Men like Abhijit Gandopadhyay are the black sheep of the Indian judiciary. But unfortunately, he is not alone. There are quite a few of them in our judiciary whose questionable conduct raises our democratic concerns. This week, we'll refer to some such cases while we discuss the instance of G. N. Saibaba and 5 others who spent almost 10 years in jail under the UAPA charges, but whose sentences were finally quashed last week, March 5, by the Bombay High Court. This Monday, March 11, the Supreme Court of India upheld the order of the Bombay High Court. We will discuss the dubious role of 2 Supreme Court judges in this case in their October 2022 judgment. See the chronology of events. In 2014, Saibaba and 5 others are arrested under UAPA for their supposed links with the Maoist groups. In 2017, the trial court indicts them, averts them life imprisonment. On 14th October 2022, the Bombay High Court sets the trial court order and acquits all 5 of them for being held on bogus charges. The next day, October 15, a Supreme Court bench stays the Bombay High Court order and instructs the re-examination of the case by a different bench of the High Court. A new bench of the Bombay High Court, in its verdict on March 5, reaffirms the earlier 2022 judgment of the Bombay High Court and acquits all the accused once again. The government moves the Supreme Court, which heard the case this Monday, March 11. The Supreme Court dismisses the government's appeal, upholds the High Court's judgment, and acquits Saibaba and all others. Now let us come to the specifics. The Supreme Court bench of Justice B. N. Gavai and Justice Sandeep Mehta refused to stay the Bombay High Court order, saying it is very, very well reasoned. The Honorable Judges said, the presumption of innocence of an accused operates with greater force when there is an acquittal. Since on an earlier occasion this court, Supreme Court, had interfered, we'll have to honor that. Otherwise, in the ordinary course, we would not have entertained this appeal. The parameters of interference with acquittal orders are very limited, the Honorable Judges said. Justice Gavai and Justice Mehta made a very significant observation here. Every word is pregnant with meaning. They said, when a High Court has acquitted an UAPA accused of wrongdoing, it's not the Supreme Court's business to sit on that judgment. The presumption of innocence of the accused is reinforced by such an acquittal order, and there is no need for interference in that judgment. The judges said, in a normal situation, this appeal by the government would not have been entertained at all by the Supreme Court. But the SC was constrained to admit the appeal by the government only because a previous bench of the Supreme Court had quashed the acquittal of Saibaba and 5 others and ordered that the case be re-examined by a different bench of the Bombay High Court. What Justices Gavai and Mehta implied, but did not clearly state, was this: the earlier Supreme Court bench decision to quash the acquittal granted by the Bombay High Court and order the re-examination of the case by a different bench of the same High Court was against the best practices of the criminal justice system. What does the standard operating procedure of jurisprudence tell us? An appeal by an aggrieved citizen against the conviction by a state agency is and must be entertained by the Supreme Court, but not the vice versa. The state's appeal against a High Court order acquitting a citizen is untenable. It's a waste of time of the highest court. To repeat, Justice Gavai and Justice Mehta said, they entertained the government's appeal and heard the case only because the earlier bench of the Apex Court had done that. That brings the spotlight on the earlier bench of the Supreme Court that had stayed the acquittal order, going against the best practices. What is worth noting is that questionable decision by the Supreme Court bench in October 2022 was also delivered in questionable circumstances. It's important to note here that the earlier acquittal judgment in Saibaba and others case came from a Bombay High Court bench of Justices Rohit B. Deo and Anil Pansari. That landmark judgment had come on October 14, 2022, a Friday afternoon. Within a few hours, the government moved the Supreme Court, and to everyone's astonishment, the Supreme Court worked with astonishing speed late that Friday night and fixed the hearing for the very next day, a Saturday, a holiday for the Supreme Court. Why this urgency? Because why not fix the hearing on Monday, the next working day? Because the intent was not to let Saibaba and others get out of jail before the case is heard. This stunned the legal fraternity. The Supreme Court has sat on Saturdays before, but that was to examine an Indian citizen's appeal against grave injustice meted out to him or her. The Supreme Court had never sat on a Saturday to set aside the acquittal of an Indian citizen or a group of citizens at the behest of the state. But this is what exactly the Supreme Court bench did on October 15, 2022, a Saturday. The bench, contrary to all established principles of jurisprudence, set aside the acquittal given by the Bombay High Court. It said, since those 6 were accused of grave crimes by the prosecution and they posed a threat to national security, the case must be rejudged by a different bench of the Bombay High Court. Who were the Honorable Supreme Court judges who delivered this stunning judgment? Well, it was a bench of Justice M.R. Shah and Justice Bela Trivedi. It needs special noting that Justice M.R. Shah, as a Supreme Court judge, has repeatedly praised Prime Minister Narendra Modi as a visionary leader under whose dynamic leadership India has grown richer, stronger, and a force to be reckoned with in the entire world. And as regards Justice Bela Trivedi, before becoming a Gujarat High Court judge, she had served as the Law Secretary of Gujarat for 2 years under the then dynamic leadership of the Chief Minister of the state, Narendra Modi. Well, they have been honorable judges, so everything cannot be said. It has to be understood, read between the lines as to what they said and what they did and why did they do it. But we must salute both the division benches of the Bombay High Court. The earlier division bench of Justice Deo and Justice Pansare, and the later division bench of Justice Binay Joshi and Justice Valmiki Menzies, who reiterated the position taken by the earlier bench. All four of them resolutely stood for Indian democracy to defend Indian Constitution. Justice Deo and Justice Pansare had in their acquittal order made an emphatic statement when they said, while the war against terror must be waged by the state with unwavering resolve, and every legitimate weapon in the armory of the state must be deployed in the fight against terror, a civil democratic society can ill afford sacrificing the procedural safeguards legislatively provided and which is an integral facet of the due process of law at the altar of perceived peril to national security. That was a befitting rebuff to the government's claim that Saibaba and others were a threat to national security and they must be kept in jail for national interest. The Supreme Court bench of Justice M.R. Shah and Justice Bela Trivedi bought into this government's trite argument and echoed exactly the same sentiment. But even after this obnoxious intervention by the Shah Trivedi bench of the Supreme Court, the Bombay High Court bench of Joshi and Menzies did not allow the false narrative of national security to trump the fundamental rights of Indian citizens. In a landmark judgment delivered last week on March 5, Joshi Menzies bench wrote, in order to attract the offense of conspiracy, besides vague allegations that they have conspired to wage war against the government or advocate armed struggle, there is no other material. They further said, downloading communist or Nazi literature from the internet or being a sympathizer of the ideology cannot be treated as an offense under UAPA. They concluded the trial held despite violations of mandatory provisions of the law itself amounts to a failure of justice. What a resounding judgment in favor of the democratic rights. How much we wish the Indian judiciary had more judges of the kind of Rohit Deos, Anil Pansares, Bijay Joshis, Valmiki Menzies, and less of the kinds of Abhijit Gandopadhyay's, M.R. Shahas, and Bela Trivedis. Thank you.